In March of 2022, YouTuber Solo Yacker, who runs the channel The Armed Fisherman, was open carrying a rifle on his person while heading to the lake when he was stopped by a few police officers from the Orange Park Police Department. The following footage is from his body cam.
What up, dude? Man, I get it. Yeah.
You got your ID and your license and all that?
Yeah, I got all that stuff.
Okay, can I see it?
Yeah, no. If you look at the 379, hear me out. Under the 379 statutes, if you actually read 379, it pertains to Fish and Wildlife Commission officers. I do have a valid fishing license, and I'm clearly going fishing. Under 901-151, unless you suspect me of a crime, have committed a crime, or about to commit a crime.
Okay, so I have had numerous calls.
That's fine.
Citizens.
Right.
Okay? So at this point, right now, all I'm trying to do is just identify you.
You don't have.
Hey, listen. And then after that, you're on your way. I understand, you know.
But I have to be.
Listen.
There has to be a crime, man. I'm not trying to be hard about this. They run my name across the state of Florida. Obviously, I'm the guy that goes around the state of Florida doing this. You know what I mean? Like, I do this. Like, this is what I do. I'm not breaking the law. And under the law, 901-151, I'm not reaching for anything, but I'm going to gladly show you. It's just a cigarette. I don't litter. See how good I am? See how I'm not trying to break any laws?
You're good, dude.
I get it, dude.
I'm not out here saying that, you know, you are.
Fishing, those are all the dates.
Can I see it?
Under Florida law, I've just done you a solid by saying, here's my fishing license. I know what you're trying to do. You're trying to run my name through David, NCIC, FCIC, all those other databases that pertain nothing to do with my fishing license. Nothing. Right now, if we're questioning my fishing license, which I clearly have, you can call FWC and they can come out and check it. Because right now, all I'm doing is trying to go fishing to that park right down the road here. Like right at the end of this block. And that's all I'm doing is just going fishing, man.
Okay. All right.
I'm not.
What's your name?
My name's Mike.
Mike what?
My name's Mike, and it's nice to meet you, bud. Unless you suspect me of a crime, but if you suspect it, then I'll gladly give you everything you're entitled to, unless you suspect me of it. If you don't suspect me of it, I would just like to kind of go on my day and just move about. And like I said, I have no ill will towards anybody. Obviously, they don't understand the law, and you understand the law better than they do. But right now, I'm just saying, hey, I'm just going fishing. I've got a valid fishing license. I have no qualms about giving my fishing license to the right authority, which, once again, under the 379.354, which is the Florida Fish and Wildlife Commission, it's their statute, basically. And I'm not reaching for nothing. .379 statutes, Florida. Right here. I wasn't joking. It says 379 statutes, fish and wildlife conservation. And that's why I say the 379 statutes.
But there's also a Florida statute,
right,
the 790.
Right.
Which
.053, 790, I know the 790s.
You know, talks about the same thing, okay?
Right.
So
what part of 790 does fishing include at any point? You tell me where the 790s and the 379 statutes with my fishing license, because right now I'm actually expressing 790.053, which actually would be illegal in the state of Florida unless I was following 790.25 section 3 subsection H, which I am.
With the fishing.
Correct. Right now.
So so with that part, the 790 that we just talked about.
Correct.
That's what gives us.
It does not.
But it does.
I have to break the law. I would have to break 790.25 or 790.053 or 790.06. Like, I'd have to break one of those statutes. And under 901-151, what crime am I committing?
The officer's sole reason for stopping Mr. Solo is the fact that he is carrying a firearm, supposedly in violation of Florida Statute 790.053, which says, except as otherwise provided by law, it is unlawful for any person to openly carry on or about his or her person any firearm. However, as Mr. Solo points out, Statute 790.25, Section 3, lists 17 exceptions to this rule, among which is subsection H, which specifically permits the open carrying of a firearm in public by a person engaged in fishing, camping, or lawful hunting or going to or returning from a fishing, camping, or lawful hunting expedition. Despite this, the officer claims he has the right to detain, investigate, and obtain the identity of Mr. Solo, based on the fact that openly carrying a firearm is generally unlawful, and the fact that they received numerous calls of a quote-unquote, suspicious, person. In the cases of Terry v. Ohio and Brown v. Texas, respectively, the U.S. Supreme Court said a law enforcement officer may not detain or identify a person unless the officer has reasonable suspicion to believe that the person stopped or identified is engaged in illegal activity. As the 11th Circuit Court of Appeals said in United States v. Gardner, reasonable suspicion requires a reasonable and articulable suspicion based upon objective facts that an individual is engaged, or about to engage, in criminal activity. Given the fact that any person who saw him would know he was going to engage in a lawful fishing, camping, or hunting expedition, and as such was lawfully permitted to carry a firearm in public, the idea that the officers could still detain and identify him is ridiculous. Furthermore, in Regalado v. State, the 4th District Court of Appeal in Florida said, stopping a person solely on the ground that the individual possesses a gun violates the Fourth Amendment. In Regalado, police received a report that a man was carrying a concealed firearm, and when officers arrived they found the tip to be true. But the court said that the officers could not detain him because, to quote, no facts and circumstances were presented to show that Regalado's carrying of a concealed weapon was without a permit and thus illegal. Orange Park is located in Clay County, which is under the jurisdiction of Florida's 1st District Court of Appeal. They said in the 2020 case of Kilburn v. State, a potentially lawful activity cannot be the sole basis for a detention. If this were allowed, the Fourth Amendment would be eviscerated. Based on the foregoing, we adopt the holding and rationale of Regalado. Therefore, by detaining and identifying Mr. Solo, the officers would be in clear and direct violation of Florida's stop and frisk law and the Fourth Amendment.
So, and it doesn't have to be a commission of a crime, it can be the investigation.
You can investigate all you want.
But, listen,
But
at this point, for us, this is a suspicious person call.
But
so
suspicion isn't until you came out here, and I'm telling you I'm going fishing. So we've just dispelled the suspicion part now. We're past suspicion. I'm not suspicion because the person that called, suspicious person. You come out here, you meet me, I'm going fishing. The suspicion part is now over.
Okay, but
right?
Listen, what I'm saying is the suspicion part isn't over for me because how do I know that you're allowed to carry? How do I know that you're not a convicted felon?
Florida,
and you're not supposed to be
Florida
with a firearm.
Here, I can pull up a case law for you. It's called Florida versus JL, State versus JL. The guy was a convicted felon. He had a firearm on him, left it in the back of an Uber. And when they went through the whole court proceedings, they threw it out because there was no suspicion of a crime. They didn't have the right to identify him because they didn't know if he'd broken a law yet. That's the key thing about 901-151. State versus J.L.
Look that up. Show that to him. I'll be right back.
Yeah, no worries. I'm not going anywhere. Right there. Asserts that the police officer did not have the requisite reasonable suspicion to justify a stop or frisk, that consequently the seizure of the firearm was unconstitutional.
It appears Mr. Solo may be slightly confused as to the holding in Florida versus JL. In that case, the police received an anonymous tip that a black male wearing a plaid shirt would be carrying a firearm at a bus stop. When the officers arrived, they saw 3 black males, including 15-year-old JL, who they detained and frisked for weapons. In a 9-0 opinion, the U.S. Supreme Court said that the officers could do neither, due to the fact that an anonymous tip which describes a person and his location, but provides no description of illegal activity or other indication of reliability, cannot support a finding of reasonable suspicion. The case did not center around a man leaving a firearm in a vehicle. Regardless, the case establishes the rule that, like here, a caller's description of a person as suspicious with no information about any illegal activity on behalf of the person, usually cannot be just grounds for detaining, frisking, or identifying him.
Probation, and they're not allowed to have this camera.
See what I'm saying? Like, this is the federal case law. This came straight out of Florida. It actually came out where I live. I know about this case law, and the only reason I know about this case law is because these are very pertinent to my constitutional rights. You know what I mean? And I'm not trying to be a hard butt about this. I'm not trying to give you a hard time. But what I am saying is that I am lawfully doing what, by law, to a T right now. And unless I am suspected of a crime, you can't ID me, man. Like, I literally have a fishing license valid. It's valid till July of this year. I'm going fishing, I'm going crabbing. This is what the net's for. You know, like, I'm not trying to give you guys a hard time. I'm really not. But, you know, I deal with this on a daily. Like, this is what I do. You know, I'm sure you've seen the YouTube channel, right?
Yeah.
Yeah,
I'm aware of several of them.
Yeah, it's 90% of them are me, man.
Oh, yeah. Did you build that?
Yes, sir.
Nice.
Thank you.
Side charges.
Yeah,
it's
a
very rare one.
Yeah, if you want, I'm literally gonna be right up here at the end of the block, right at the thing, and I think there's fishing there. I don't know 100% yet until I usually get to where I'm going fishing. If there's a sign that says no fishing, I'll just be.
There used to be one. I'm not sure.
If there is a sign there that says no fishing and I see it, I'm turning my butt around and I'll go right back to my car and I'll be done. But like I said, I'm pretty sure there's fishing. People told me there's fishing over here, so.
Yeah, people have been out here fishing.
Yeah. Yes, sir. I think we're good. All right.
After a brief and casual conversation, Mr. Solo went on his way. Ultimately, Mr. Solo gets an A. Knowledge of one's rights is important, but it's equally as important to be aware of the state and local laws where you live in order to fully effectuate them. It's also important to be able to cite the laws and cases in your defense. Mr. Solo displayed the same amount of legal knowledge that all citizens should have, and his ability to cite his sources was remarkable. Probably the only thing he could have done better was to have better understood the background of the JL case. The officer gets a B. While he was clearly not well educated on Florida's open carry laws and misunderstood the extent of his authority under Florida's stop and frisk law and the Fourth Amendment, he was also not hostile, threatening, or aggressive. And he was willing, at least to some degree, to hear Mr. Solo's side of the argument. It's also safe to note that not all encounters with law enforcement officers are detainments. According to California v. Hodari, absent the use of physical force, an encounter between a citizen and a law enforcement officer only becomes a detainment when the officer displays a significant show of authority which would convey to a reasonable person that he is not free to leave, and the person actually submits to that show of authority. It could be difficult for a court to determine when exactly in this encounter a reasonable person would not feel free to leave, and thus when he was detained.